Hi guys, e don say social media don catch fire. Nigerians are beginning to react as Bola Ahmed Tinubu and APC doesn't want to respond to the petition that Labour Party and other political parties petitioned at the tribunal concerning the 2023 presidential election. Guys, watch this video and you will hear what Ayo and Dr. Ruben has to say, and don't forget to share your thoughts with us.
That the presidential election petitions court hadn't yet responded to the 5 petitioners in terms of setting a date for its hearing. When we talk about the case and the time taken to hear out, bearing in mind, as we said earlier on, that we have about 50 more days to May 29, it brings up a question, what the reason for the delay is. And that's just my big question this morning, is that why hasn't the petitions court responded with a date to the petitioners as to when to begin hearing? What is the reason for the delay? Are there things that we're waiting for? Are there procedures that ought to be done? Why is there a delay, bearing in mind the importance of the cases and the time limit that we have? Because as was said by INEC, go to court, go to court. They've gone to court now. Now it's the responsibility of the court to take action and respond to the petitioners. We look forward to seeing that or hearing the response in the next few days, and of course the case or the trial or tribunal taking on and going on as it ought to.
INEC has said in the guidelines is that it's from EC8A, B, C, D, E that you use. In other words, it's a combination of both electronic and manual. And that's why INEC can come forward and say, well, there were glitches in terms of reporting on the portal, the IRF portal, but it was immaterial because from EC8A to E is the main document. As had been pointed out in the Adeleke case in Osun by the Court of Appeal. So, but where is the problem? Number one, ahead of the election, INEC promised heaven and earth, and we had persons on this program saying BVAS and IREV were the game changer. This is the major thing that has happened to Nigerian democratic process. The resort to technology. INEC spokespersons appeared on television and elsewhere boasting that there will be transmission of results, real time, online, technology will change everything. Now, the same INEC is saying another thing. So this should be a lesson for public officials. If you have the law and you have your own guidelines and you are acting within the scope of the law, then don't go and promise things you don't know or that you are not ready to deliver. So people are relying on INEC's own statements, and there's evidence that has been provided to show INEC officials saying this is what we will do. So which means that part of the problem with the Electoral Act 2022 is that those who are even supposed to operationalize the law do not understand it. So one of the fallouts of this electoral process will be people taking a second look at that Electoral Act and committing it to act. Section 149 of the same Electoral Act 2022 says, well, if you are aggrieved, you go to court. So, and that is what has happened with 5 political parties going to the tribunal. However, part of the problem in our electoral adjudication system is that the presumption of regularity is on the part of INEC. The burden of proof is heavily resting on the petitioners. And there are lawyers who have argued that, no, maybe that's not very fair. But in any case, that's what we have. That's the law as we have it at the moment. But the presidential, election petition tribunal has not yet fixed a date for hearing. These are probably some of the issues that will come up, along with Section 131 of the 1999 Constitution, along with Section 134.2 of the 1999 Constitution, and other technical issues that may be raised in terms of how practically that election was conducted. But our own appeal in the midst of all of this is to say, well, people should have faith in the judicial system. People should not resort to their own devices, and we should allow the judiciary to do its work.